All right, hello everybody. Today we've got something that's timely in a sense. So this is, goodness, 1798. On the 10th of November, 1798, today's the 11th, there were resolutions that were written by Thomas Jefferson, handed over to Wilson Carey Nicholas of Virginia, and then handed over to John Breckinridge of Kentucky. These resolutions were edited slightly, but from the point that they got to Jefferson to the point that Breckinridge introduced them in the Kentucky legislature. But these resolutions were adopted by the Kentucky General Assembly on the 10th of November in 1798. They were adopted as a response to the Alien and Sedition Acts, which were one of the first really big hits against the Constitution. Basically, these were laws that made certain types of speech and certain types of expression in the press that were critical of the government, especially criminal, federal crimes. This, of course, is against the First Amendment, and these resolutions, and similar set of resolutions in Virginia, written by Madison, or at least drafted by Madison, were adopted around this time in protest of these laws. And from these resolutions, you can get a lot of detail about the principles of at least what was attempted to be limited government. It's worth noting that I kind of got the idea for this little discussion by watching today's episode of the 10th Amendment Center's Path to Liberty podcast, or video podcast, whatever you want to call it. Michael Bolden over there and Mike Meharry especially are doing amazing work over there. They've got a few people over there who are doing really good work for them, but Michael Bolden kind of is the face of that Path to Liberty podcast, and his look into the Kentucky resolutions of 1798 were really good today and kind of inspired me to do a little bit of a follow-up on that. So I'm going to read a few quotes from these resolutions. I'm not going to read the whole thing because it's about 5 pages, and I don't want to waste your guys' time. But what we're going to do is we're going to go through a few very important clauses and sentences in these resolutions. We're going to examine how they relate to the principles of limited government, if possible, and see where that leads us today. So, starting out, in the first part, so the resolutions are separated into about, 10 parts or 9 or 10 parts? I'm just going to call them parts because they're just labeled with Roman numerals. But at the very beginning, at the very start of part 1, we have resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. Now, it's worth noting that these, the part of the seed crystal for the American Revolution were the intolerable acts that required that America submit to British rule, Parliament rule, King George's rule under all cases whatsoever. And if the idea was to go from one sovereign to another, that would not have really changed the situation that much except a change of the ruler. No, instead, the revolution was at least significantly built upon a concept of limited government based on kind of Lockean principles that were kind of filtered through the American mind over the 100 years since Locke's Second Treatise. The point that we need to remember is that unlimited submission, or the principle of unlimited submission to government, to whatever, is a declaration of slavery. If you must, morally, legally, ethically, whatever, submit to whatever some certain body pronounces about you, your property, your family, etc., you are effectively owned by that group. Now, the purpose of limited government was to provide, what would you call it? Some kind of glue to hold society together, to keep things, normal and orderly, without having that kind of principle of unlimited submission. Instead, there's a principle of limited submission due to a set of enumerated rules that are written in such a way that pretty much everybody can read and understand them, which is not diametrically opposed, but significantly opposed to any principle of unlimited submission, which would be, effectively slavery. Now, part 1 continues that They, that is the states, constituted a general government for special purposes, delegated to that government certain definite powers. This is one of the key principles of limited government, that a group gets together to take powers that they do have and delegate the operation of some of those powers to a different body. That different body is not above them in a sense. It is more like an agent as compared to a master, right? The states delegated some of their powers of government to the federal government. Only certain things that they did delegate are what's delegated, and not everything that they forgot to undelegate, say that this is ours, do they maintain. This was a principle of government back in the 1700s, that if you wrote a document that said that, that if you wrote a document about what government could and couldn't do, if you didn't say, I reserve this power, I reserve this power, I reserve this power, I reserve this right to myself, the assumption was that governments would take the rest, basically. And this is, again, in not 100% diametric opposition, but significant opposition to that principle. Continuing. Whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Now, these acts that are not delegated are usurpations. They are thefts of power, thefts of rights, thefts of property of the people, or in this case, the states. And these are thefts right now, not once a court has decided that these are things. This is another important principle of limited government. The ability, in fact, the right of people under that government to protest and even to, under certain circumstances, obstruct the enforcement of certain acts or laws created by the government because they are against what is written in the Constitution, for instance. Continuing, that the government created by this compact was not made for the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its powers. This is a point that is straight out of Locke. The idea that no man should be his own judge, or that no man can be his own judge and still remain impartial. From a Lockean perspective, from a Revolutionary wartime perspective, the goal was to have a set of interlocking responsibilities and authorities that made it so that nobody decided cases for themselves, that the federal government was not the judge of its own powers, of the extent of its own powers, that the states were in general accountable to the people. Now, this changed in only a few years later after Marbury versus Madison, which said that the federal Supreme Court is the arbiter of what the Constitution means, which is a huge violation of this principle that no man be his own judge. And, takes America on a big step towards totalitarianism from what is, an attempt, at least, at limited government. Moving on to part number 2. Having delegated to Congress a power to punish treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the laws of nations, and no other crimes whatever. The principle here is that when there is a list in a written constitution, that list is exhaustive. Not that that list is examples that can be then expanded by the purposes or by the power of sloppy language into other examples, but that when you get a list in the Constitution, it must be exhaustive, because to assume that the list includes things that are not in the list means that pretty much anything can go in to fill in that blank. Again, you go from what is, in principle at least, an attempt at a limited government to something that is, in principle, not prevented from being totalitarian in any way whatsoever. Moving on to part 3. It is true as a general principle, and is also expressly delegated by one of the amendments to the Constitution, that quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And that no end quote, and that no power over the freedom of religion, freedom of speech, or freedom of the press being delegated to the United States by the Constitution, nor prohibited by it to the states, all lawful powers respecting the same did of right remain and were reserved to the states or to the people. This part 3 of these resolutions, are basically saying the Alien and Sedition Acts violate the black letter law of the Constitution. Therefore, they must necessarily be unconstitutional, regardless of what the federal government says. These laws prevent a person from speaking out about the problems of their government, from making fun of government officials, and these things are specifically protected by the First Amendment. In black letter law, there's no question of interpretation here, is what they're trying to get at in Part 3. And therefore, it's not even true that we need to wait for someone to kind of give a learned opinion about whether this is a violation. Any literate person can tell that the Alien and Sedition Acts violate the First Amendment. Furthermore, at the end of Section 3, he continues, therefore, the Act of Congress of the United States passed on the 14th day of June 1798 a specific act entitled An Act in Addition to the Act for Punishment of Certain Crimes Against the United States, again, very specific, which does abridge the freedom of the press, violation of black letter constitutional law, is not law, but is altogether void and of no effect. So right here, they're being very clear about which law specifically in this, that was passed by Congress is void, what it violates in the Constitution, and explains that therefore it is void now, and we don't need to wait for anybody to tell us that it's void. In Part 4, that alien friends are under the jurisdiction and protection of the laws of the state wherein they are, and that no power over them has been delegated to the United States, ... An act concerning aliens, which assumes power over alien friends not delegated by the Constitution, is not law, but is altogether void and of no force. Again, we have the people of a state saying, we did not delegate to you this power. These people are here as our guests in our state, and you have no power over them. Therefore, this specific law that you passed, which violates this constitutional principle, is therefore void now, not when you say it's void. Similarly, Part 5. This Commonwealth does admit the migration of alien friends described as a subject of the said act concerning aliens, that a provision against prohibiting their migration is a provision against all acts equivalent thereto, or it would be nugatory, meaningless. That to remove them when migrated is equivalent to a prohibition of their migration and is therefore contrary to the said provision of the Constitution and void. Here's another principle of limited government. Hair splitting, to come up with a workaround that doesn't violate the black letter law of the Constitution, but does violate it like one minor step away, or even one big step away, or even several big steps away. If the effect of a law that is put forth and adopted by Congress does not allow the things that are specifically allowed in the Constitution to happen, then those laws are also void, and they must be, because to admit that you can not do X, but you can do Y, which is basically equivalent to X, or is a logical conclusion from X, right, is something that is unavoidable with X, means that you're doing X. That's an important principle of limited government, again, that you can't have these little workarounds where it's like, oh, well, it's not like, we said you can't say this. It's just that we had a 3-letter agency go and tell you that you're going to get in trouble probably, and there will be issues if you do say this. That, just as much as blanketly saying that you may not do X, is just as unconstitutional and therefore is void now when it happens, and not when some court says so. In Part 6, somewhere about in the middle of it, the same act undertaking to authorize the president to remove a person out of the United States who is under the protection of the law on his own, the president's, suspicion, without accusation, without jury, without public trial, without confrontation of the witnesses against him, without having witnesses in his favor, without defense, without counsel, is contrary to these provisions also of the Constitution, is therefore not law, but utterly void and of no force. This is an argument about separation of powers, another important principle of supposed limited government. If you have delegated the power to enforce and interpret laws to the judiciary in some sense, if you have guaranteed the certain rights to people that are being that are basically defendants against the state in a legal sense, you must provide them with their rights, or else you have violated their rights. what basically is being said here is that the federal government has taken the law from the jurisdiction of the courts of the states or even the federal courts and given the president the ability to say, hey, you, sir, you over there, I expel you from the country. That violates due process. It violates the right to a fair trial with a jury and counsel and witnesses and such. And by violating these rights, the law in question has been voided. It is of no force. It is of no force now. We don't need to wait for a court. Continuing in Part 6, transferring the power of judging any person who is under the protection of the laws from the courts to the President of the United States as is undertaken by the same act concerning aliens, is against the article of the Constitution which provides that, quote, the judicial power of the United States shall be vested in courts. It goes on from there in the quote, and then the part goes on as well. The said act is void for that reason also. Not to repeat myself too much, but it's void now. We need to wait for a court. Because you can't conveniently transfer powers from the judicial branch to the executive branch because it's easy and it makes things faster. That also is void and a usurpation of power. If the federal government wanted to enact a law like this, they could not take away the due process rights of these friendly aliens. And they could also not delegate the court's judgment and the due process and the procedures that go with the due process of a court process to the president's say-so. This is another thing that you could apply to, like, executive agency regulations, right? It is unconstitutional, by the same logic, it is unconstitutional for an executive branch agency to make rules that have the force of law, which is why all that stuff is unconstitutional. In Part 7, the construction applied by the general government, as is evinced by sundry of their proceedings, to those parts of the Constitution of the United States which delegate to Congress a power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States, and to make all laws which shall be necessary and proper for carrying into execution the powers vested by the Constitution in the government of the United States, or any department thereof, goes to the destruction of all the limits prescribed to their power by the Constitution. This is what I refer to as the no blanket clause principle. If government is to be limited in some way, right, there cannot be any blanket clauses, or any clauses that could be interpreted in a blanket sense cannot be interpreted that way and still be constitutional. This one gets at both necessary and proper, which does not mean convenient. It means necessary and proper, both of them. A good example would be the First Bank of the United States, the Second Bank of the United States, and the Federal Reserve. These are convenient for certain government power exercises, but they're not necessary and they're not proper. And in addition, there's the General Welfare Clause. The term general welfare is so vague as to be effectively meaningless. Any tyrant can choose to make some kind of absurd Benthamite calculation and say, this particular policy will hurt these people and help these people, but I say that it will help these people more than it hurts these people. Therefore, it is in the general welfare. No, in fact, in order for government to be limited, it must not have any of these blanket clauses, or at least any clauses. If you interpret any clauses as blanket clauses, you have violated a crucial principle of limited government, and you are back at totalitarianism. It might just be totalitarianism that isn't choosing to do everything it can do, but it recognizes no internal limits to its own power. Finally, in Section 9, this Commonwealth is determined, as it doubts not its co-states are, tamely to submit to undelegated and consequently unlimited powers in no man or body of men on earth, that if the acts before specified should stand, these conclusions, the conclusions of totalitarianism, would flow from them, that the general government may place any act they think proper on the list of crimes and punish it themselves, whether enumerated or not enumerated by the Constitution as cognizable by them, that they may transfer its cognizance to the President or any other person who may himself be the accuser, counsel, judge, and jury, whose suspicions may be the evidence, his order the sentence, his officer the executioner, and his breast the sole record of the transaction. That a very numerous and valuable description of the inhabitants of these states, being by this President reduced as outlaws to the absolute dominion of one man, and the barrier of the Constitution thus swept away from us all, no rampart now remains against the passions and the power of a majority of Congress. Two things from this passage. Without these principles, the government is total. It is not a limited government. It is not a servant of the people. It is a totalitarian state, and we are the slaves of that totalitarian state so long as we submit to it. Further, there's the acknowledgement here that total government in any sense is enslavement. It is banditry. And that the people, therefore, have a right to defend themselves against slavers, against banditry. These things are both implied by this section of chapter or part 9 of the resolutions. These resolutions were written by Jefferson. They were adapted by Wilson Carey Nicholas and John Breckinridge. They removed the term nullification to be a little bit more acceptable. But you can see that they still include a fervent declaration against totalitarian government and reaffirm the principle that the American federal government was supposed to be a limited one. We don't live in that world today, unfortunately. The government admits to practically no limits on its power. Even the First Amendment isn't safe now because the government is seeking the power to define certain things as misinformation or hate speech and to thereby find a power to regulate them. If you are interested in limited government, you cannot allow the principles of your government to allow it to enact totalitarian rule, no matter how kind or how just or how good your representatives might be today, they might not be tomorrow. And a government that is not limited by principles is by definition total, whether it chooses to make mincemeat of all of your wishes and designs or not. That is the heart of the Kentucky resolutions that were written originally, that were drafted by Jefferson. And this is one of those things that is extremely important. Anytime you see the government decide to interpret something in such a way that it gives it effectively unlimited power, it has stepped over the line between limited government, which might be acceptable to some people, right? It might be that some people would say, I want a government to do these certain things for me, and it's not necessary that I have exact consent over every single one of their actions. I have delegated certain aspects of my property or its management to them, and they get to make the decision through some process that they've decided, usually a representative one, right? In the same way, you wouldn't want necessarily to be a part of a society where a person who commits a bunch of murders is then investigated rightfully by security officials and says, I'm out, I leave now that I'm under an investigation. You can see how a person might want to hold that person to account, that multiple murderer who's just decided, oh no, I'm leaving, I'm out, you can't do anything to me now, right? This was kind of a attempt to create a limited government, a state that operates off of at least a limited, form of consent of the people, and to dash away the principles that made it such turns it back into exactly what the people and what any reasonable person would want to be away from. Basically, a system where they are owned, they are slaves to an unaccountable body of representatives or whatever else they call themselves, while they still demand and claim total power over your entire existence. These principles are very important to remember, even if your idealistically an anarchist, right? Because covenants of any sort that are created by people are going to have these kinds of questions. And the point is that even a private covenant is going to have to obey these principles that form what is effectively a limited government. And it can do that outside of the bounds of being a state, right? To put it another way, you might disapprove of Netflix's raising its prices by $1 a month, for instance, but you still retain the right to leave Netflix at any time, and you also would be able to see the difference between Netflix raising their price by $1 per month and Netflix raising their price by $1 million a month, right? You would expect that you wouldn't be forced to pay for even a month of that if they chose to change it and not let you know, for instance. You would hope that there would be some kind of method for you to avoid that you have to be notified of in advance of price changes, things like that. Anyway. Governments are everywhere. That is to say, states are everywhere. They're all coercive to one degree or another. What happened in the 1700s was an attempt to move from might makes right totalitarian government, kings, absolute monarchs, to a form of what was an attempt at limited government. I'm going through Locke's second treatise right now. I'm producing both an analysis and a critique of it from a voluntarist perspective. But like these resolutions distill, as I've shown, a bunch of different principles that help to keep a government or any kind of body with any kind of authority limited, right? Unlimited submission is slavery. Delegation is delegation of certain definite powers, not indefinite powers. When the body decides to usurp powers that have not been delegated to it, those acts are void now, not when a court decides. The body should not be able to judge the extent of its own powers, right? Lists in these kinds of constitutions must be exhaustive. They cannot be vague. They cannot be treated as vague because when they're treated as vague, they offer the ability to include any other desired power into the list, which, again, violates the principles of limited government. When the government violates the black letter law of this Constitution that they have, agreed together to enforce, what they've done is wrong right then. It is not true that they need to wait for people to approve that that what this is a violation. It's a black letter law violation that any literate person can see. When you void laws like this, you generally want to explain which law or which proclamation or which act in particular is the usurpation and why, and then declare it to be void. We have the principle that doing workarounds by hair splitting and not necessarily banning X, but banning something that is an inevitable conclusion of X is a no-go because it gives the government power to ban X effectively, although not quite in name. That it's the effects of these actions that determines whether they're usurpations and not whether they exactly violate the black letter law, because if they violate an inevitable conclusion of the black letter law, it's just as if they violated the black letter law. Separation of powers. That transfers of power cannot simply be done because they're convenient. That blanket clauses must not be allowed in these kinds of documents. These are all principles that at least from a perspective of, like a minarchist perspective, prevent a state from becoming a totalitarian state. If a state obeyed all of these principles, consistently, then, well, they wouldn't be a totalitarian state. They wouldn't be claiming ownership over their people to rule them in whatever way they see fit. They would be claiming a very limited number of powers, and there would be principles in place that prevented them from overstepping. And we know, of course, that once a state gets the power to be a state, to be coercive in that way, and still have moral righteousness, that often these principles go to the sidelines, which is what we see today. Anyway, I'm kind of starting to ramble, but I got over the principles, I went over the resolutions, I'll have a link to the resolutions as they were written. I'll have a link to Jefferson's draft of the resolutions, and I'll have a link to the episode of the 10th Amendment Center's Path to Liberty podcast that inspired this, all in the description. I hope you have enjoyed this, found it interesting. As always, thanks for watching, thanks for listening, and I'll see you next time.